Hello and welcome to the Minimum Competence episode for Friday, December 5th, 2025. I'm your host for today, Andrew Leahy, an assistant professor of law at Drexel Klein School of Law. On today's episode, Trump's D.C. troop deployment upheld, Tom Goldstein's fight to sell his home, a grand jury win for Letitia James, and a $300 million fee bid in the Anthropic case. Let's remember, all art is autobiographical. The Pearl is the oyster's autobiography. And read today's legal news. On this day in legal history, December 5th, 1933, the United States ratified the 21st Amendment to the Constitution, officially ending the era of national prohibition. This amendment repealed the 18th Amendment, which had banned the manufacture, sale, and transportation of intoxicating liquors since 1920. Prohibition, championed by temperance movements and moral reformers, was initially seen as a solution to social problems such as crime and poverty. However, over the following decade, it led instead to a surge in organized crime, illegal speakeasies, and widespread disregard for the law. The 21st Amendment is unique in American legal history. It is the only amendment to repeal a previous amendment. It is also the only amendment ratified through state conventions rather than by state legislatures, a strategic move to bypass potential legislative gridlock. Utah became the 36th state to ratify the amendment, securing the 3/4 majority needed for adoption. The repeal of prohibition returned control over alcohol regulation to the states, many of which continued restrictions at the local level. The amendment's passage marked a shift toward a more pragmatic and less moralistic approach to federal lawmaking. It also highlighted the limits of federal power to regulate personal behavior and underscored the complexities of enforcing unpopular laws. In the broader context of constitutional law, the 21st Amendment demonstrated the capacity of the Constitution to adapt and self-correct. It remains a pivotal example of how constitutional amendments can respond to changing public sentiment and unintended legal consequences. A federal appeals court has allowed President Donald Trump to continue deploying National Guard troops in Washington, D.C., halting a lower court ruling that would have required the troops to withdraw by December 11th. The temporary order from the D.C. Circuit Court does not address the underlying legality of the deployment, but permits it to proceed while litigation continues. The deployment, which began in August, intensified after a November 26th shooting near the White House left 2 National Guard members injured, one fatally. Trump responded by sending 500 additional troops and renewing his call to halt immigration from what he called, quote, third world countries, after a 29-year-old Afghan national was charged in the attack. D.C. Attorney General Brian Schwab sued the administration in September, arguing Trump unlawfully took over local policing authority and violated federal restrictions on military involvement in domestic law enforcement. A federal judge initially sided with Schwab, calling the deployment likely unlawful, but delayed enforcement of her ruling to allow time for appeal. The Trump administration maintains it can deploy troops to D.C. without local approval, citing the city's unique federal status. Meanwhile, similar deployments in other Democratic-led cities have sparked lawsuits and accusations that Trump is using federal force for political purposes. Lower courts have largely ruled against these moves, and the Supreme Court is expected to weigh in on the legality of the Chicago deployment soon. Tom Goldstein, a prominent Washington attorney and co-founder of SCOTUSBlog, is fighting to sell his $3 million home in D.C.'s Wesley Heights to fund his defense against 22 financial crime charges, including tax evasion. Prosecutors allege that Goldstein, who has made millions as a poker player, misrepresented his financial situation to obtain loans, including one used to purchase the property. A Maryland federal judge barred the sale, ruling the house is likely connected to the alleged crimes. Goldstein has appealed, arguing that blocking the sale violates his Sixth Amendment right to use untainted assets for legal defense, and insists the home is not tied to the alleged misconduct. The appeal is before the Fourth Circuit, where Goldstein, representing himself, says he's accumulated millions in legal fees. Prosecutors maintain the house is tainted because Goldstein omitted over $15 million in debt from the mortgage application. The home is also collateral for Goldstein's appearance bond due to his being labeled a flight risk. One of Goldstein's key financial backers, litigation funder Parabellum Capital, is a witness in the case, but not accused of wrongdoing. Legal experts say his effort to sell his house faces steep odds given the property's legal entanglements and standard federal practices regarding tainted assets. A federal grand jury has declined to indict New York Attorney General Letitia James, rejecting prosecutors' second attempt to bring criminal charges against her, according to sources familiar with the matter. The Justice Department had sought to revive a case involving allegations of bank fraud and false statements related to a mortgage after the initial indictment was dismissed in November due to the unlawful appointment of the prosecutor, Lindsay Halligan. Despite the setback, prosecutors reportedly plan to seek a new indictment. James, a Democrat and prominent critic of Donald Trump, was accused of misrepresenting financial information to obtain favorable mortgage terms on a Virginia property. She pleaded not guilty to the original charges. The failed indictment effort comes amid broader DOJ efforts targeting Trump's critics, including former FBI Director James Comey and ex-National Security Advisor John Bolton, cases that have also faced legal hurdles. Grand jury rejections are rare, as prosecutors usually face a very low threshold of probable cause to proceed. James is now the highest profile figure to have such a case rejected during Trump's second term. The president has publicly attacked James for leading a civil fraud lawsuit against him, which resulted in a massive financial penalty, later reduced on appeal, but with Trump still found liable for fraud. Lawyers representing authors and publishers in a $1.5 billion copyright settlement with AI company Anthropic have requested $300 million in legal fees, amounting to 20% of the total settlement. Filed in federal court in San Francisco, the fee request comes after Anthropic agreed in October to settle claims it used pirated books to train its AI models, including its commercial product Claude. As part of the agreement, Anthropic will pay over $3,000 per infringed work, destroy the infringing datasets, and certify they are not part of its commercial systems. The legal team, led by Sussman Godfrey and Leif Cabraser, argued that the fee is, quote, conservative by class action standards, citing more than 26,000 hours of high-risk work. The settlement, which received preliminary approval in September, is being described as the largest reported copyright class action resolution to date. Anthropic has denied wrongdoing and retains the right to contest the fee amount. Authors have until January 15th to opt out of the class action and pursue their individual claims. A final fairness hearing before U.S. District Judge William Alsup is scheduled for April, where objections from class members and fee disputes will be reviewed. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece that will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Wolfgang Amadeus Mozart, a composer of some note. On December 5th, 1791, the world lost one of its greatest musical minds in Mozart. Just 35 years old at the time of his death, Mozart left behind an astonishing body of work that shaped the course of Western classical music. His death, shrouded in speculation and mystery, came while he was in the midst of composing what would become one of his most profound and haunting works, the Requiem in D minor. The Lacrimosa movement in particular captures the emotional gravity of that moment as if echoing his own impending end. Although Mozart did not live to finish the Requiem, the fragments he left behind were completed by his student, Franz Xaver Sussmayer, guided by sketches and oral instruction. The Lacrimosa, with its solemn melodies and aching harmonies, stands as one of the most emotionally resonant sections of the work. Franz Liszt later transcribed it for solo piano, creating a version that retains its choral intensity while adding a layer of intimate, virtuosic expressiveness. Listening to Liszt's transcription of the Lacrimosa is like hearing Mozart's farewell whispered through the keys of a piano. Stark, mournful, and deeply human. December 5th, then, is not only the date of Mozart's passing, but also a reminder of the enduring beauty he left behind, etched into every phrase of the Requiem. His music, especially in this piece, speaks across centuries, to the depths of loss and the hope of transcendence. Without further ado, Mozart's Requiem in D minor. Enjoy.